But your Lordship is 136. Before that, allow me to proceed my own way of 5 minutes only.
No, good.
Then your Lordship.
No. Have we interrupted you? We are just
I'm saying one of these, before I answer this question, no interruption. The Lordship has been hearing the patience.
Yes.
I am only going to give a Lordship the conduct on only 6 dates, subject to my Lord's discretion. This deserves to be discussed. He is not a person interested. He is now holding to ransom a 10 times larger project with a new man. Allow me to give those dates first. Just those 6 dates. Only 6 dates. They're crucial. And a 9 at the third level, 136, your Lordship has the discretion completely to not entertain it on these dates alone. The MOAT is 29/1/2024.
Yes.
Now, astonishingly, within 15 days, on 16/2/24, he seeks a return of 20 crores. He's totally wrong to say why he sought that 20 crores. I'll come to that. It's very interesting. That is 15 days. Now, let's just note on the side, 29/1 was entered into because the idea was that an MOAT, which is actually should be called an MOU, would be converted into a DA after all of us, the 16 people or 20 householders, with many more tenants, sat together and approved and agreed. Consensus as item was the bridging gap between the MOAT and the DA, which never happened. Now, it was realized between 29 and 16th February that it would not happen. So, this he seeks back. Now, I will read a very interesting letter at page 325. What's the date of that?
29/1/24.
In a minute. That he wants to get out there. So just don't finish the dates first. Now, the development agreement is never entered into. The termination happens on 6/9/25, which is a year and a half later. It is 18 months later. And this man should get a interim mandamus to come back, is what he's seeking. And the new developer comes on 22/9/25. The new developer, in an extremely short time, has got all the same permissions which he never got. I'll give you a page just now. He, just note, has spent more than 20-25 crores already. He has deposited with the society. He has paid hardship compensation to members. And if this man gets in this dispute, will be deprivation of these flats for everybody. His entire claim sounds in money and damages.
No,
now come to
compensation means they have got out of the premises.
No, that's the process. He's paying compensation, they are getting out. Now, if he
how many occupants are there?
18. There are about 60 plus tenants. 24. 16 plus 8. 24.
No, owners. 60 occupants.
16.
No. Owners are 16. Tenants are 8.
Okay, so they will all.
Occupants will be at least 100.
Temporary accommodation.
Yes. It will be 100 if you take the family members and all that.
So what is the stage? What is the stage now?
They are in the process of doing this. He's doing everything now. This is already when? Last year. You had 2 courts, concurrent findings against him. Your Lordship is 12 months beyond September 25 also today. Now bear with me. Just come to his conduct. Come to 325. This is not a man who wanted to do this at all. He was hedging his bets. He got lucky because the division bench rightly said you lost, you can't come back. So he now come up with the SLP. The SLP itself an afterthought. I'll just show this. Actually, Mr. Kadam, appearing for Mr. Kaul's client, is the one who wanted, after losing Section 9 for single judge, to go to arbitration. As it is, not not saying that I will not go with fetters. He was losing specific performance, so he said we'll go to arbitration.
No, sure.
Yeah, immediately. First come to 325. This is on day 1. Now, he writes to the escrow agent who keeps his 20 crores. He only bothered about his 20 crores. He writes to the escrow agent, this, your Lordship is marking, this is Palli is marking. This is written.
P6.
Yes, P6, but written by him to his escrow agent holding 20 crores.
Neil Ramani.
Let's turn the page. Para 3. In the light of the provisions of the MOAT, you shall retain, deal with and dispose of the FDR as follows. See the bottom of that page. In the event that the developer accepts the title of the society in respect to the said property by or before the cut-off date. So he accepts. But the parties fail to settle and initial the development agreement by or before the cut-off date. Unless otherwise instructed to you by the parties jointly, the MOAT itself shall stand cancelled and the FDR shall be returned by you to the developer within a period of 2 days from the date of demand by the developer without any. This is writing within day 1. Then next para, middle.
These are all standard clauses in an escrow letter.
No, that's all right. But see, the agreement doesn't happen. This is conditional on the agreement.
Yes.
Now, just note, he's writing this. Note one more thing.
Where is his withdrawal on 20 days? That shows.
Yes, on 16th of February 2024.
Where is that?
At page 340 is the next one. I'm going in sequence. 340. And then he says he used it for my work. Just see what he did. It's completely wrong. Factually wrong. He says to your lordship, I took 20 crores to do Mr. Singhvi's work. Now just see what he did. Come to 340. I hope this letter finds you well. This is within 15 days. He has no skin in the game. What kind of a developer is he? Developer who has a skin in the game will write in 15 days. Now, what your lordship is told is that he took 20 and spent it for me. No.
Where does he say for making payment to the...
A, nothing. B, no, I take a proof positive.
Because that demand...
No, straight away, allow me.
That demand, according to...
Now, he makes a payment. I'll answer this.
Came on 24th September.
Yes.
No, my lord, that's the premium demand. The lease rental demand had already come on 31st of January 31st of January 2024, the lease rental demand came, and that is why the letter on 16th February was written.
Just note 2 facts here. When is your termination, Mr. Kaul's client? 6/9/25. That is 18 months later. First point. Between your lordship's letter at 340 and 18 months later, he has spent a total of 9 out of the 20 crores.
Which you have offered in the repayment in the termination.
That is coming. Don't forget that. Because this man is saying that 15 days after the agreement, he took 20 crores away to pay for me. 18 months later, he has paid 9 out of 20. Pause. Of these 18 months, he paid actually the 9 within 7 months after and then did nothing. The 7 months from 16 to by September 24, he had paid the 9. He was doing nothing after that.
So when did you, pursuant to this letter, give him back the 20?
Yes, page 354. Page 354. Page 354. He can claim damages at the most today. Money. He can't in specie stop this contract.
No, just you.
He has shown that he's not interested in the contract. He wants to blackmail me. Let's come to 354.
Yes.
Very good, no? Sorry, 346. Just one. Where is that? We suddenly offered him back. That letter, yeah, please. Sorry, 454. Yes, my termination letter offered it back on 454. 454.
No, that is 9 crore.
Yes.
This 20 crore.
Same day. Released immediately.
February 24th.
Yes. My lord, what is he telling my lord that he's spending money after 15 days? I thought my lord is asking when I can only pay him when I found out that he has spent 9 crores. Now, even 9 crores, he has spent nothing. He first, let me give you a break up. 2 crores he spent within a month or two. 7 crores he spends within 7 months later. And then for 1 year he's quiet. And now we are 1 year further. Now 2 more things. Come to 454. I'll just let you go see. 454. One second. In fairness, I find out the total what you've done is this. And I offer him, this letter is a termination letter, 454. My lord will mark para 30. Now, let's see clause 24 of the development agreement. Bandra West. He's blackmailing me, Bandra West. This, this 2 minutes only. I'll take still home. Come to 285. This is the MOAT itself by which he is swearing. He never allows the DA to come. DA would have come consensus. There is a failure of consensus. We find out that he is not performing. But in the MOAT itself, see this. The party shall execute such. I'm sorry. Page 285.
Yes.
The party shall execute such definitive documents, writings, including development agreement, shall execute. This is the real bargain. This is only an understanding which your Lordship is finding that he is functioning on. Shall execute development agreement, power of attorney, such other document may be necessary with respect to transactions completed. Parties shall ensure that the draft development agreement and all incidental documents shall be settled and initiated by the society members and developers before 21st February. That's why the dates now match. The members find his performance bad, so they're not agreeing. So he said, I want to get out. The date matches directly. Read further. The developer shall provide a 10 days. Date is very important, 21st February. That's the date of the letter. Now let's note one more page. Come to page 425. Same one. Next one. Second one.
This is the letter of intent. What you are reading is the letter of intent.
MOAT. No, the so-called MOAT itself.
Starts from
It will become a MOAT
yes,
between us.
you are reading the MOAT itself.
MOAT itself.
So you are saying that the draft development should have been furnished by 20.
It's a shall. It's what we this MOAT, which is a fancy word, is an understanding to contract.
A moat is normally what is
It's a
outside.
moat between us. It's a moat between us, brothers. He has built a fortress inside. The owner is now outside of the moat and the developer is inside the fortress.
Yes, Balbir Singh Umar.
2 minutes more. This is 2 minutes. 425. 425. The developer has gone inside the fortress, but is keeping me out of the moat also. 426 brothers. 425 at 426. Now, brothers, this 425 is very interesting. It's a letter in June 25 before the termination saying, all this while you've taken me for a ride and not done any timeline. This letter before termination is very important. My anguish. 426 does my Lord have? Starting at 425. Now see the middle of 426. In the SGPM held, the members raised serious concerns regarding the continued delay, the lack of adherence to the agreed timelines, which have been delayed for more than old timelines, the original ones. The society has repeatedly conveyed its apprehension over the unsatisfactory fees and no meaningful corrective action from your end, leading to loss of faith. Now, therefore, I give him new timelines at 427. Just come to the new timelines. Please find the detailed timelines along with certain other crucial issues. The timeline to achieve key milestones shall be 1. Revise floor plans by 15 June. Nothing happens. I terminate him after giving him new.
That's all we've seen.
Revised plan. There's a mortgage mutated entry which needs to be removed by 30th June. Approval with respect to 9-meter road sexually proposed by 30th June. BANDRA C apartments property registered card by 15th July. Without prejudice by legal rights. Lastly, Malas, 2 things and I'm done. Section 10 and 14 after Lordship's amendment of the SRA still recognizes fully damages if he has. Not in specie relief by right.
Yes, who is Mr. Balbir Singh? We need to.
Yes, yes. I'm deeply obliged.
I'm
So Mr.
submitting.
Sundram is also there.
My lord, I'm for
He's the builder who has
the
come.
builder, and what is most important is this. I'm the trigger. Why did this come to be filed? I'll just give you 4 dates, my lords. It all becomes clear. My lords, on an agreement was entered into with me as the builder, as a new developer. That agreement was on 22nd September
Yes.
of 2025.
Kunika, you are Kunika.
Yes. The agreement is entered into with me on 22nd September. They then rushed to court without disclosing my agreement, but saying that we are worried they're going to get into other agreements. So they filed their Section 9 for the first time on 23rd September, 1 day later. On 26th September, Dr. Singhvi's client says, look, we've already transferred it, given the development right to so-and-so. 26 September 25. To date, they have not bothered about making me a party. To date. And the interim order, which was passed by my lord, injuncts me also.
No.
The status quo is square me also. It will affect me.
No, we wanted to hear because
Yes.
the division bench did not.
That's why, give me 1 minute, my lord. I want to show your lordship.
Ask them to take instructions for arbitrator and.
This is the only point I want to bring up. Please see these dates and only these dates. They filed a Section 9 on 23rd September 25, There is no ad interim
That's all
order.
right. That's all right. Now,
Now, note the 4 dates, Manoj.
Yeah.
Please, these are relevant. I'll explain why. The section 9 is disposed of on 9th October 25. 6th October 25. Dismissed. There is no interim order.
so has Justice Patel entered the reference?
They, not yet.
Because of
They
statute.
have not written, my lord. They have not written in.
All right.
My lord, I have a different
Yes,
suggestion.
Mr. Balbi.
My lord, can I
Yes,
just
No,
give
no,
me one?
Just finish it.
My lord, I just 1 minute and no more, my lord. I'll give you my suggestion and this is what I want to leave it. My lord, from 23rd September till your lordship's order, there was no interim order pending the appeal, pending anything, pending the section 9, nothing at all. Now, my lords, what is their best case? Best case is division bench should have either decided my section 37 or if it was going to the arbitrator, should have said go to the arbitrator who will consider it afresh. But there cannot be an ad interim status quo order in the meantime. Well, that is my point. My point is if they want to set the clock back in some way. My lord, the question.
No, you have not seen para 3.
Yes.
That is what the grievance on the first hearing was, that we are giving you the arbitrator all contentions left open except what has been denied by single judge, which includes this denial of relief and specific performance.
Let the single judge decide that also. I mean, let the arbitrator decide that.
Yes, Mr. Balbi.
But the only Singhvi is
Well, but I wanted to
No,
give
same
the
party.
my
Yes, same
legal
party.
opinion.
Mr. Kaul.
only one
There is a case
only
where
one date.
few residents in Bombay chose to have a developer. They call for a bid. They select you out of 4 as early as January 24. We have seen the MOAT. We have seen, thanks to you, the correspondence, painstaking detail you have taken us. We have seen what he has shown us that your attempt to take back the money in less than, a month. When the agreement has just commenced. In this scenario, in a matter of this nature between parties, why should a court of law put you back as the developer? You work out your remedies before the arbitrator.
Well, let me, I need to respond to it. I need to.
Yes.
Well, firstly, within 15 days, why it was taken was on 31st of January itself,
Yeah.
the demand had been raised by the Revenue Office for over 2 crores for lease rent. So it's not that I gave an FD of 20 crores and took it back after 15 days. The clause provided that for lease rentals and premium, you will utilize the 20 crores. That demand came on 31st of January 2024. On 16th of February, I wrote to them, and on 21st, I immediately made the payment for that. It is for that. So it's very easy to say that I took it back. I took it for what? I took it for the purpose that the clause provides for. I didn't drift away from the agreement. That's what the clause provides for. That's one. Secondly, my lord, what's very important for your lordships to know is on 15th of Jan, I just give 4 dates. It's important. Because in September of 2025, they terminate the agreement. On 15th of January 2025, they write to us to say, I have now appointed a new lawyer. Please pay the fee of the new lawyer also. We do that. This is page 374. 373 is their letter on 15th of January 2025. Then after that, my lords, they write to us on 30th of June 2025. Just take these 4 days. These are important. 30th of June 2025, they again write to me to say that can we discuss and expedite and conclude the process. On 20th of July 2025, I write to them the letter I had read out to your lordships, all the steps that I was taking and the development agreement now needs to be executed is what I said.
We don't want to say anything on merits, but we are not convinced. Yes.
Well, just let me complete this.
Yes, we'll
Let me complete this. On 20th of August 2025, please have just page 323, 441 for a minute, my lords. Please have 441 for a minute, my lords. So there's something turns on that.
Yes. That is
Please have,
20th August letter.
yes, my lords, 25. Second para. As the months of July and August were marked by multiple festivals, including Independence Day and Janmashtami, along with extended weekends, many of our members were traveling. Consequently, the society's managing committee was unable to convene a meeting to deliberate the contents of your mail, finalize the response. We shall be furnishing responses. This is what they're writing to me till 20th of August. And my lords, their termination letter says that on 10th of August, our society is already terminated. They were right.
In an interim reply, we all used to advise, pending my final this one. Heard Mr. Neeraj Kishan Kaul.
Manoj,
Leonard Senior.
may I with respect say only two things? Manoj, may I with respect only say two things? I showed to your lordships the order of the division bench.
Workout damages.
No, my lords. All that I'm saying is that order of
That
the
is why,
division.
Mr. Kaul, 1 hour and 10 minutes
Because
only on this.
I can never complain
you have-
about the patience that your lordship shows. That's not my grievance at all.
You have an absolutely correct position. You have taken that division bench, not adverted to the merits. That is why we issued notice.
Manoj,
But now that we have seen the MOAT, the correspondence, termination, the single judge order, and the division bench order, we are convinced that this is not.
Manoj, may I with respect only say two things? Manoj, your lordships could send us to arbitration. That's not an issue. At least let the arbitral tribunal decide whether to modify or not the order that your lordships have passed for 10 days. Secondly, my lords, at least I must be allowed to go to the tribunal without the riders the single judge has put. My lords, I've been told that I can't ask for specific performance. He's ruled on the merits of the matter, and the court says, the impugned order says you can go and argue before the arbitral tribunal minus what he said. Now, my lords, what will I argue before the arbitral tribunal if all the findings given by the Section 9 court are held binding on me?
What do you say?
All the time.
Forget the interim. We are not going to continue the interim order. You may deny, answer his prayer for specific performance and saying he has not made out a case. How can you foreclose his right to specific performance?
No. So I understand. First thing should be clear. This prolongation of interim order should not be there. My lord has observed that, directly or indirectly.
But let
Number two. No, number two.
Performance.
I'm answering
Alternatively, damages.
No, I'm answering that. No, I'm answering that.
All open.
I'm answering that.
But is
The finding is written at.
single judge also says
No, your Lordship, page 643, the single judge says it's a prima facie character.
No,
So my lord is being told that in final award he won't get it. He can argue the final award.
No.
In
Come to the final.
643.
Yes.
643.
663, my lord.
1 minute, sir.
Is the Section 9
He
court.
doesn't want.
643 is award, Balas, he will argue.
No, not the award. Suppose he makes a prayer for specific performance in the claim.
Yes. In the final award, let him make it.
Alternative damages.
Yes.
Will you say that this para forecloses him? Where is that para?
No, because it says para
Para 40 on page
My
663.
minute, sir. What problem is, your lordship is now discussing a 17. He is now in a 17. In the award, it is not foreclosed. In the final hearing, he can take both the points.
Just see para 40, but without the absolute and binding right.
So please clarify that in the final award, it will lie.
That's
Final
it.
award.
Yes.
Because you can't have it in the interim.
He's entitled
That's
to
all.
ask. You may say no. You may say case is not made out. You may say it
In
is
the
a
final
development
award-
agreement involving minute.
As long as your lordship's words are clear, it's unexceptionable. I'm not objecting. In final award, I'm not objecting.
Once the matter is referred for arbitration,
Yes.
he may set up any claim of each one.
Yes.
The visibility and whether he's actually entitled.
Arbitrary.
We can't report, but for the matter being.
But for the arbitral award,
It's only
that's
for
all.
17
He's saying
purposes.
this for 17.
17 purposes.
My learned friend's client is misleading your lordship by saying it's for 17. That's the problem.
No, we will try.
I said I'm being
Let's
referred to
clarify.
arbitration
That's all.
by tying both my hands. Where do I go and swim?
Now we
Say
are-
both my hands are tied and my legs are tied.
Now,
Manoj, may I only make one submission and I leave it at that? And lordships have been very kind. Manoj, one is that I can't be relegated to arbitration with all these riders. That's one of both the 37 court and the section.
clarify it straight.
That is one. Secondly, my lords, all that I'm saying is admittedly the 37 court, which I have a right to argue before, did not decide on. No. All I'm saying is, can I not be permitted at least before the arbitral tribunal to argue a section 17?
That's right.
Manoj, what I'm saying, no,
See, Mr.
just a minute,
Mr.
Manoj,
Kaul-
why can I not argue there?
Many projects in Bombay are stalled like this.
That's the whole point.
Because this is a good scheme where the old residents in old buildings, we've seen a few of them, are waiting because it gets locked up in litigation. So we want to clarify this part.
Manoj, your lodgers are right, but there are also cases where developers spend and another developer comes and manipulates some members of the society and takes over the project.
There is havoc there and there is a perpetual fear.
But Manoj, your lodgers with your vast experience on this side know how developers also manipulate societies. There have been any number of cases, my lord, where one developer had spent money, invested.
Led to that.
He is one such developer.
Yes,
he is describing himself.
And other
Defining
schemes, SRA schemes, all locking up in litigation because developers put
Yes, so my lord, here comes a dishonest developer after I
We
spent 10
wanted to
crores.
only satisfy that whether there was any scope for it. Heard Mr. Neeraj Kishan Kaul, learned senior advocate for the petitioner. Is Mr. Rodgi there? I heard Mr. Mukul Rodgi, learned senior advocate for the petitioner, and Mr. Neeraj Kishan Kaul.
Manoj, can I make one submission and I leave it? I'm sorry I'm interrupting your lodges. Manoj, the developer should then also be made a party to the arbitration. It can't be that I will be left in some...
That will be dealt with under the...
But my lords, I will be free to move an application to make him a party.
Don't say
That has to be.
anything.
No, and
How are you concerned?
no, and you make...
Manoj, my
you apply-
learned friend heart beats for the developer.
Yes, it does.
No.
And Mr. Dr. Abhishek Singhvi, Mr. C.S. Sundaram and Mr. Balbir Singh, learned senior advocates for the respondents. At the last hearing on 31st July 26, the senior counsels for the petitioners made a grievance that the division bench did not hear them on merits and also foreclosed their rights to move for interim relief before the arbitrator. We had issued notice and passed interim orders which were in operation till today. Full stop. Today, we have heard parties at great length. We have perused the MOAT full form is
Memorandum of Agreed Terms.
Memorandum of
Actually,
Agreed
it should
Terms.
have been disagreed terms. Manoj.
Memorandum of Agreed Terms, bracket MOAT, comma, the correspondence, the crucial correspondence, comma, the termination letter of 6th September 2025, as well as perused minutely the judgment of the learned single judge, as well as the division bench. We are convinced that there is no case for interference under Article 136 of the Constitution of India. At this stage, Mr. Neeraj Kishan Kaul raises a grievance that paragraph 40 of the order of the single judge, as well as the operative portion of the order of the division bench, could be misunderstood to mean that the petitioners are foreclosed from asking for the relief of specific performance as a final relief in arbitration. We clarify that the petitioners before the arbitrator will be entitled to seek as part of their final relief a prayer for specific performance. At the same time, the respondents will be able to shall raise all objections that are available to him. Will be entitled to raise all objections entitled to him to oppose the relief
Obliged.
of specific performance as well as other reliefs which the petitioners may claim. With this clarification, while upholding the order of the single judge and the division bench, we dispose of the special
Manoj, just one last request, Manoj. The arbitral tribunal will decide uninfluenced by the observation.
We also make it clear. We say needless to observe
Final.
that the arbitral tribunal will be uninfluenced by the observations of the orders of the court below as well as our order.
Very grateful. Extremely grateful.
Grateful. The transaction matters definitely more or less. For the afternoon, there are different bases. Thank you.
Great.